Hello guys, welcome back to my channel. So in today's video we'll be talking extensively on agency. We will look at the definition of it, we'll look at classes of agency, rights and duties of agency, how agency can be terminated, and we'll take series of questions. I won't want to waste time in this video. I want to first appreciate persons that have subscribed to this channel, reached out to me also to tell me how the videos I've been uploading has been helping them learn on the go. So thank you so much. So moving on straight ahead, let's look at what agency relationship is all about. Agency relationship is a relationship that exists between two persons, the agent and the principal. Now, the agent is considered in law to act or to represent the principal in such a way that the agent is able to affect the principal's legal position with the third party. Now, I know you might not really get it, but in case you don't, please rewind a bit. You can go back and we'll watch it as much as you want. Now, there are two important things to note here. First is that the agent is contracting on behalf of the principal. That's the first one. Secondly, to dispose his property, right? There are different ways an agency relationship can exist or may arise. It can be by agreement, either with words or in writing, right, or impliedly. It can also be by subsequent ratification by the principal of acts done on his behalf by the agent. This particular one is we're looking at incorporation of a company also, and we're talking about promoters. Right? We know promoters are those persons that in regards to a given project, he does all acts to ensure that that project is up and running, which includes getting funds for that project and some other thing. Okay, there are certain times I could have engaged into one or two contracts, right? Now, when the company has been incorporated, the company can now ratify those contracts in a way that says that he was acting on behalf of the company, right? So that's one or more ways of an agency relationship arising. Also, it can also be by operation of law under the doctrine of necessity, right? Let's talk about the effect of agency. I will just read. It said, when an agent enters into a contract on behalf of his principal, two legal consequences result. Firstly, a relationship is created between his principal and the third party. And secondly, reciprocal rights and liabilities are created between the principal and the third party. So in essence, although the agent is the contracting party by action, he is not acting by himself, but rather for and on behalf of his principal. Right? So I will want you to replay this again. It will make sense in a way because this explains the agent's relationship with the principal, right? So agency is quite different from trust. It is quite different from guarantor or surety. It's quite different from bailment, master or servant relationship. It's quite different. If you look at your study pack, you'll find reasons why. But now let's look at capacity to enter into an agency relationship, right? The first is the capacity to act as the principal, and the second is capacity of both parties to enter into a relationship. Now, but the general rule is the liability of the principal or the agent to the third party will depend on the contractual capacity of the party against whom the action is brought. So, for instance, if the party becomes insane or bankrupt, the agency will be terminated right away. So, this is more or less like saying, okay, when does one have capacity to enter into an agency relationship? Or when does one have the capacity to say, okay, yes, I can have an agent to act on my own behalf, right? So that is just what this is saying about. I highlighted this place where it says a person who lacks capacity to enter into a contract may, however, act as an agent for another. So more or less like saying an infant, a baby, can act as an agent to a principal who is competent. However, the baby cannot be the principal. A person with capacity may, however, not act as an agent for an infant, right? So it's just like saying a baby can be an agent for a principal, but the principal cannot be an agent for the baby. And that's what it says here. right? So let's go to the classes of agents. um, I know in the study pack there are times when they will ask us to give six um, classes of agents, and this is where it will be an issue, because sometimes we might just say three, or might just read three, which is general agent, universal agent, and special agent. um, However, it's the question is being stated, right? um, there are three main class of agents. All other ones you would find fall under the special agents, right? So if they ask for six, you can list the six of them, excluding special agents. But if they ask for the three classes of agents, you just list general agents, universal agents, and special agents. Now, a general agent is an agent with business, trade, or profession, usually of continuous nature, according to our study pack here. Where the appointment of a general agent becomes unrestricted, such agent is said to be universal agent. So I think the clause here is that a general agent comes with restriction, while universal agent comes without restriction. Let's look at the different types of special agents. We have the factor agent, we have the broker, we have auctioneer, we have decredier agent. Now, you can actually read this in your study pack to understand what it means fully, right? Let's go straight to creation of agency. Now, under the creation of agency, we're talking about how can an agency relationship arise. Now, we said express appointment. Express here can be in form of writing or by words, right? So when two parties come together and they write out how the terms of their relationship is all about, whereby one is acting on behalf of the other, this this act is an express appointment. Now, implied is not written, it's not stated, right? But it's more or less by inference. For example, in a firm of partners, a partner entering into a contract on behalf of the firm is assumed to be acting as an agent of other partners. Yeah, in partnership agreement, for instance, this is what it's just saying. We know that a general partner is an agent of other partners, right? So it may not be in writing, right? But with our knowledge of what general partner is, right, we could infer that when one partner acts, is acting on behalf of other partner. There's also agency of necessity, agency by estoppels, apparent agency, agency by ratification. I've said this here. Ratification, I give an example as to a promoter and a company, right? He said for agency by ratification to exist, the following conditions must be satisfied. At the time of making a contract, the agent must purport to be acting on behalf of his soon-to-be principal, right? You could just read the conditions here. The principal must have been in existence and have capacity at the time of the agent purported to act for him. The principal must be competent to act at both the date of the contract and the date of ratification. So there's a point of competence right here. The contract must be a valid one that is not void ab initio. Time is of essence of an agency to be created by ratification, and so the principal must ratify the act within a reasonable time of doing the unauthorized act, right? So we have different forms of authority, right? Agency relationships are dependent on the nature of authority vested on the agent. Now, there is actual or express authority. This refers to specific powers given to an agent orally, in writing, and sometimes under seal. We should always note this that when we're looking at express, we're talking about any authority given in writing or expressed orally. We're talking about implied, we're looking at an authority not maybe stated or written, but maybe a part of under law. It has been. So we can now infer that it applies to that particular setting. Let me just say, for instance, let me quote partnership right now. We understand that under partnership, if the agreement was not, maybe the agreement between partners was not expressly agreed on, maybe it was implied. We know that yes, there's no agreement between them that was said, but then the partnership act covers it. So more or less, in an agency agreement, an agent has the implied authority to do acts that are incidental to the act for which he has actual authority on. Let me also paint an example. If the authority, let's say real estate agents, for instance, they are given authority to sell a property. The authority was to sell the property, but they also have an implied authority to enter into that property and just look around, check what the amenities are in there, check other facilities to aid them to sell that property. I don't know if this makes sense. Now, apparent authority, sometimes called ostensible authority, it arises when a third party believes that a person has the authority of the principal to act on his behalf, either from the latter's carelessness or the fact that he held the person out as having the authority to so act. So in this one is when the third party is perceiving or believing that this person is acting on behalf of another person, right? I think there's a question in the past question. Is this place was stated that when an agent has ostensible authority, what kind of authority is that? Something of that nature, right? And the answer is apparent authority, right? So let's look at the rights of an agent. Okay, as a general rule, an agent has the right to receive indemnity from the principal for any cost reasonably incurred in the course of performance of his duty. An agent is to be paid the reward or commission for work done. An agent is entitled to have his lawful actions ratified by this principal. A disclosed principal must also assume responsibility and liability for the authorized acts of the agent. An agent has the right to enforce a contract against third parties. An agent has the right of laying over the goods of his principal for his unpaid commission and other monies due to him. Right? So I'm going to read out the duties of an agent too. Every agent owes his principal the following duties. The agent is bound to conduct the principal's business according to his directions or instruction. He must not delegate his authority unless expressly or so instructed by his principal. He must act in good faith and avoid conflicts of interest. He must exercise due care and skill. He must not make secret profits. He must not disclose confidential information to the third parties, and he must render accounts as when due. Now, duties of the principal. The duties of the principal include the following: to pay the agent's fee or commission, to indemnify the agent for all lawful acts carried out by the agent on his behalf, to ratify the acts of the agent as the case may be. A disclosed principal is under a duty to assume responsibility and liability for the authorized acts of the agent, and as a general rule, the principal is liable to third parties under all contracts entered into by the agent under the agency, whether the principal is disclosed or not. Now, that is the duty of both the agent and the principal, and also the rights of both the agent and the principal, what they are entitled to and what they are obligated to do. Let's look at the effect of contract made by agents. Now, we have three effects. Like, this effect of contract made by agent can be classified under three categories or three headings. There's an effect of contract made by the agent when the principal is named, when the principal is unnamed, and when the principal is undisclosed. There are effects to it. When the principal is named, where an agent contracts on behalf of a named principal, it is the principal alone that acquires the right and liabilities. When the principal is unnamed, right, and the agent acts for him under the scope of his authority, only the principal still acquires the rights and liabilities. Now, this is where it gets tricky. In the situation where the agent conceals both the identity and the fact that it is acting for somebody, the third party is at liberty to enforce the contract against both the agent or the principal where he discovers the principal. So we should get this correctly. For the named and unnamed, the principal alone. Or for the undisclosed, it is the It's both of them. Now let's look at how an agency can be terminated. An agency can be terminated in two main ways, either by expressed act of the parties or operation under law. Now, on like if we're talking about the act by the parties, let's say both of them agree to dissolve the relationship, or one of them revoke the contract. Revoking can be in form of the agent renouncing his authority to act or to carry out act on behalf of the principal. So that one is by the act of the parties. Now, operation under law in form of death of either party, or when either party becomes insane, bankrupt, or by frustration. Also, if the relationship is illegal ab initio, and there are other ways, right? So, in summary, we could say an agency is more like the relationship between two parties, whereby one is the agent and the other is the principal, and one is acting on behalf of one, the agent is acting on behalf of the principal, and the agent is acting on behalf of the principal in his dealings with the third party. So if we get this correctly, I think we would be certain to ace this topic, right? So basically, I just did a brush up on this topic, right? The essence of all this is in preparation for the business law exam, right? So I'm wishing everybody that will be sitting for this exam big success. You can check out my other videos. I did well to explain them, right? And I think it has been helpful to some persons. So the videos came as a result of my preparation for the business law exam, and it's a commitment to help other persons too that are writing these exams with me to ensure that they ace this exam, right? And thank you so much for following up. Do well to subscribe, like, and share this video. All right, cheers.